Hi, today I'm going to be talking about liability laws and how those can be used in environmental regulation. I'd like to give a special thank you to Professor Jeremy Williams and his class in Dubai for suggesting the topic. Hope you guys enjoyed the videos. Thanks for watching them. So, I grew up on a farm, and in the small town I grew up in, at least the impression I got was that you only got a lawyer involved in something if you were greedy or if something had really gone wrong. So I did not think of the legal system here in the US as something that could help deal with environmental issues. It would leave a bad taste in the mouth if I heard that someone was suing somebody else. Well, as I got into grad school, especially law school, I started learning that the legal system actually does perform a lot of things, creates a lot of incentives that are supposed to deter people from doing things. So it's not just that people are seeking money after the fact. This system of liability rules really creates incentives for people to act differently in the first place. So one of the places we see that is in environmental law. So if a factory is along a creek and it is releasing its water waste into that creek without treating that waste, it's polluting and making it so that the creek is less able to perform its usual functions, to be habitat for a bunch of different kinds of fish, to be a water source for maybe some people who live downstream from the factory. Well, liability laws can be used to get the factory to actually internalize that externality. How does that work? Well, if you, say, live in a village that's downstream from this factory, and that village gets its water from the creek, the factory is polluting the creek, making it so that the village has to either find a different water source or has to treat it in a much more substantial way that costs a lot more money. Well, that village or the people in it could potentially file a lawsuit against the factory and say, this factory is degrading the quality of the water to the extent that it costs us a lot more to be able to use this water as our water source. Now, if the liability laws are such that the village is able to sue for that issue, what we would see is that the factory would think about this. It would think about how, oh, the village downstream can file a lawsuit against me if I put this waste into the creek, and I'm going to have to pay the costs that are incurred by those people, the added cost, because of that pollution. Well, as we've talked about in environmental economics, that's actually exactly how we want people to think. We want people to think about both the added cost and added benefits of doing something related to environmental quality. So if it's a factory, we would say the optimal amount of pollution is where the marginal abatement cost is equal to the marginal benefits. So by using the liability laws, we can actually get a factory to emit the efficient amount of pollution if those liability laws are such that people actually are able to use the legal system to get them to pay for those costs. Now, obviously, there's some friction there. We'll talk about transaction costs, and I'll talk about that more in another video. Lawyers cost a lot of money. Using the legal system costs a lot of money. So there are lots of frictions that make it so that the liability law system doesn't always get us exactly where we want to be. But learning about this got me to think about these laws very differently than I did before I was trained in grad school. Instead of thinking of suing someone as just a bad thing, I started to think about how liability laws can get producers, polluters, to think about what they're doing and the downstream effects of what they'll do. And not only does that allow for compensation of people who've been harmed, but probably even more importantly, what that does is that creates incentives for them to not pollute as much in the first place, because they're thinking about that potential liability cost they'll face in the future. It means they'll reduce their pollution before they even get sued. We call that deterrence, and that's a really important part of law and economics, the subfield that I specialize in. How do we look at the incentives created by different laws? A huge part of that is looking at deterrence. How do we stop potential criminals from committing crimes? How do we look at incentives that will deter potential polluters from polluting too much? Well, liability laws play a big part of that. And so just one distinction that I'll make about liability laws, the two main types that we have are negligence liability and strict liability. So strict liability means that if someone does something, they will be responsible for the damages of that action, no matter how careful they were. So if you're a factory and you face strict liability, maybe you're handling a hazardous substance. If you face strict liability, it means no matter how careful you are with that hazardous substance, if someone gets harmed by that hazardous substance, you're going to be on the hook for that. That's a strict liability regime. We don't care how careful you were. We use that for situations like hazardous substance or really dangerous activities. If you're keeping a tiger as a pet in the US, that would be subject to strict liability. We would say, no matter how careful you are, you're choosing to have a tiger as a pet. We're going to hold you responsible for any damages caused by that tiger. You could think of a hazardous substance in a similar way. I don't have a tiger with me, I have a teddy with me. Oh, my puppy's getting big. He's barely a lapdog anymore. But Teddy says hi, don't you? You're not dangerous like a tiger. So with Teddy, instead of strict liability, what I would face is negligence liability, which means if I take reasonable care to keep people safe from Teddy, then I'm not going to be responsible for the damages. I'm only going to be responsible if Teddy causes damages by, say, biting someone, if I don't take reasonable care to prevent that bad thing from happening. Same thing is true with pollution. If it's a general pollutant, not a hazardous substance, here in the US, we would hold that to a negligence liability standard, meaning if you took reasonable care to prevent your pollutant from causing harm, we're not going to hold you responsible for the damages that it causes. We'll only hold you responsible for the damages if you haven't taken reasonable care. And so, of course, reasonable care is a fuzzy term, and where the law draws that line can be very difficult to discern. Here in the US and in England, we use a common law system where it's really judges usually, or sometimes juries, who are deciding what that reasonable care is, where to draw that line. In civil law countries like most of continental Europe, it is codified. They've written laws that say in much more detail what that standard is. And so a big difference with those two systems, common law and civil law, the judges are kind of deciding where the line is in common law, and that means they're also setting precedent. So future judges are going to look at what previous judges said. In civil law countries, that's not true. All of the judges are going to look at what the code says, what the law written down by the legislature says reasonable care is. They won't look at what other judges have done, at least not in the same precedential way that the common law system uses. But for now, negligence liability means we care whether you took reasonable care or not. Strict liability, it doesn't matter. No matter how careful you were, we're going to hold you responsible for damages caused by that activity or substance that you were dealing with. So that's it for liability today. I'll be posting another video about the Coase theorem, which talks more about property rights, and I'll get more into transaction costs with that. Thanks.